Good afternoon. Calling our next case, Stokes versus Swofford. This is a 20-minute mini oral argument on the application. You have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of your own time, and you can begin when you're ready, although we are going to have an emergency alert. I think it will happen after arguments are completed in this case, but in case they happen during your argument or during rebuttal, just stop talking. We'll push pause on the clock, and then we'll start back up.
May it please the court, Michael Cook on behalf of Dr. Michael Swofford and Southfield Radiology Associates. Try to reserve 4 minutes for rebuttal. We'll see how I do. In 2006, after hearing much of the same arguments that you've heard in this case twice now, all 7 justices agreed specialty includes subspecialties like cardiology, oncology, infectious disease. Now you're being asked to overrule that unanimous decision. And while a majority of this court has the raw power to do so, I do think the unanimity on that point is significant. Overruling an unanimous agreement of this court's predecessor should take something extreme, a change in statute, or all malpractice cases coming to an effective halt. Nothing like that has happened. The argument against Woodard hasn't changed. It's basically this. The statute doesn't say subspecialty. That's an easy argument to make in pretty much any case involving statutory interpretation. You can always say it doesn't say something more specific. I can make the same argument. The statute doesn't say you only match the primary specialty. So it doesn't say primary, it doesn't say subspecialty. It says specialty. And as all the justices in this court, on this court at the time in Woodard agreed, specialty, the definition of it, includes primary and subspecialties as they're commonly understood. The common understanding of specialty also supports their ruling. A cardiologist is a specialist. Cardiology is a specialty to everyone, except those who are asking you to overrule Woodard. Overruling Woodard also won't solve any problems. You're still going to have overlapping specialties. I think you see that in the case that comes up after this one. Those are 2 primary specialties, there's still overlap. You're still going to have practitioners who practice in 2 different primary specialties. One example might be taken from the Reeves case. We have a family practitioner who also was practicing in an emergency capacity. That defendant will then have 2. You'll still have to choose which one is the most relevant specialty. It creates additional problems too. And last time I pointed out, and my brief points out, the potential conflict you'll have if you say specialist or specialty only refers to a primary specialty with MCL 600.2912A. If you interpret specialty to only refer to primary specialties, that statute becomes unworkable. And this interpretation of the 2 has to be the same because they were enacted at the same time, they use the same terms, and they're within the same act. And this court has observed, I think quite correctly and logically, that when you have that situation, the terms have to be interpreted the same. So overruling Woodard doesn't solve any problems. You're still going to have to choose among specialties and cases. It doesn't, and it also creates new ones. And overruling Woodard reverts back to the time before the statute came into effect. If you think there are problems in applying Woodard, if you think there are inconsistencies now, you're not going to like what happens when it's all kicked over to 2169 sub 2 and MCR, excuse me, MRE 702. That's the inconsistency that prompted the legislature to enact the statute we're here talking about. So we're here on my application, and you might be asking, what can we do? Well, what I'm asking you to do is to clarify one point in Woodard that I think has been misconstrued. And you see it in the published opinion in this case, in the unpublished opinion in Higgins, which was also cited and relied on by the Court of Appeals in this case. The problem comes when you start holding physicians to standard of care or saying that a jury should assess them based on specialties that they don't actually possess. In Higgins' case, it was very clear. That doctor was a diagnostic radiologist. He never did any additional training in neuroradiology. And Higgins said, well, since he was reading a neuro image, he was practicing neuroradiology, and so the most relevant specialty is neuroradiology. He was going to have to sit through a trial and have a jury be told that he is to be judged by the standard of neuroradiology. He had no such training in that. That's inherently unfair. And the point that you can correct is this line from Woodard, where it says, the relevant specialty is, quote, the specialty engaged in by the defendant physician during the course of the malpractice. Courts are misunderstanding, the court in this case and the court in Higgins are misunderstanding the phrase specialty engaged in. It doesn't mean the specific thing the doctor was doing at the time. When you look at how this court has defined specialty, it's been consistent. Specialty is how the physician limits their practice, what they focus on. Certain physicians focus on treating certain kinds of patients, certain kinds of diseases. You have to limit and focus your practice. So once the physician does that, they are engaging in that specialty. So the 3 steps I think you need to set out to clarify that is 1, you find out what are the defendant's specialties. Define the universe of specialties. What specialties does he have specialized focus or practice in? 2, if there's only 1, and in this case, 1, that's the specialty that he's held to.
Even if, excuse me, even if the service that's being provided is outside of that specialty?
So that's a good question. In this case, the service provided was not outside the specialty, right? All diagnostic radiologists read this type of image. An example where it would be outside the specialty, use an extreme example. An internal medicine specialist decides to do an appendectomy, right? Yes, the standard of care is still internal medicine, and you're not going to have any sort of internist willing to stand up and say, it is outside the standard of care to try an appendectomy on a patient for an internal medicine specialist. So yes, that does set the standard of care. Even if he's doing some general surgical procedure, that doesn't make him a general surgeon, right? So getting back to my 3 steps. So that's step, if they only have 1, that's the standard they're held to. And if they're doing something really outside of their practice, that's going to be an easy case for the plaintiff, I think. Step 2, if there are multiple specialties, so let's say the defendant does practice neuroradiology, does practice diagnostic radiology, yes, you're going to look at the specific act that they're dealing with. So let's use the plaintiff's expert as an example. He's a neuroradiologist, spends the majority, I think 90%, he said, of his time reviewing neuroimages. But he does review some diagnostic radiology studies, some non-neuro images. Let's say he committed malpractice while reviewing a non-neuroradiology. He's not going to be held to the standard of a neuroradiologist because he also practices and focuses and has been trained on diagnostic radiology, right? But if he's doing a neuroimage, he's definitely going to be held to the standard of a neuroradiologist because that is also a specialty he possesses. The real issue here, the real issue that the plaintiff's counsel and the defense have disagreed on up to this point is whether or not Dr. Swofford had both specialties. We argue he didn't. And in 2006, he dramatically shifted his practice. He was qualified in practicing neuroradiology, had a career change. He decided to go become a diagnostic radiologist and practice as a diagnostic radiologist. That's what he was doing at the time. So we argued, under those facts, the trial court correctly determined that he was practicing as a diagnostic radiologist. This court, and I think any appellate court, should review that determination for clear error. It's a factual determination that the court makes. And I don't think there's any clear error in making that determination.
Counsel, I think the statute itself seems to be concerned about having underqualified experts. You seem to be arguing that overqualified experts also cannot be experts on cases. Is that accurate?
That's absolutely accurate. I don't think it really is just concerned with underqualified. I describe it as an apples-to-apples statute. It is matching up the specialty that the defendant practices, and the expert has to practice that specialty.
So why not look at what the negligence section, say, has proposed? I mean, you'd have the broad category, because you do have, I mean, it does feel odd to say that someone that is a diagnostic radiologist but has a specialty, which is within diagnostic radiology, isn't diagnostic radiology. So the negligence section is obviously proposing that you can kind of then get past step 1, and then the courts can do the balancing below to decide if that subspecialty really matters. Because sometimes it does, and maybe sometimes it doesn't.
So here's the problem with the negligence section's proposal. Specialty, they want to define that as just primary specialty. That isn't what the statute says. But let's say that you do that. You define it as primary specialty, and then you punt everything beyond that in terms of can a cardiologist testify against an internist? Can an internist testify against a cardiologist? So let me back up too. Internal medicine is a primary specialty, cardiology is the sub, right?
Right. We know internal medicine is
yeah.
the category that's very broad, of course.
Yeah,
Right.
and that's, I think, the easiest one for everyone to
Yes.
follow and understand, because we know what these people are and they do. If you punt all that down to subsection 2, and you punt that over to 702, you're getting into the inconsistencies and problems that led to the legislature passing this in the first place. You're going to have some courts say, yeah, in this case, a cardiologist can testify against an internist because he says he knows internal medicine. Other courts will say, no, I don't think that's sufficient. Then you're going to have across-the-board inconsistency. And I don't think that's at all what the legislature wanted, particularly when you look at how the statute changed. Because initially it was the same specialty or related similar specialty. And they took that out to require just the same specialty. They're requiring a level of precision of matching apples to apples. Yes, I do think they're concerned with a physician sitting there and being judged by a subspecialist in some field. They are asking and looking for a matching. That, again, is where Woodard, the first step was, how do we define specialty? The concepts of subspecialties fit within those definitions of specialty.
And so and I realize from the record so far, it appears that there was an affidavit of merit for a neuroradiologist, using a neuroradiologist's standard of care. And I understand your argument, that should be a diagnostic radiologist standard of care. I'm just wondering, could a neuroradiologist if we were to say, no, it's just a broad category, he's a diagnostic radiologist, could he provide an affidavit on not the neuroradiologist standard of care, but the regular broad category of standard of care?
Could the neuroradiologist provide? No, I don't think so. Primarily because that's not how he spends the majority of his time.
He's under the banner of diagnostic radiology, though, right?
He is, but then when he's specializing and practicing on the specialty of neuroradiology, it gets really hard.
We know.
Yeah.
You're starting with the premise that they're all specialties, right? So if they're all specialties and it's not this and then the subspecialties,
Yes.
they're all specialties.
They all fall within that term specialty.
And the test should be, based on what the statute says, is that the goal is for the experts to match up, right? So if your client had let his certificate lapse, but was still doing a lot of that work, would he be
Yes.
practicing?
Yeah, if he was still practicing as a neuroradiologist, even if he let the certification lapse, he would still be practicing on neuroradiology.
The distinction here is that he stopped doing that in 2006, which was 7 years before he read this image.
Yes.
brought this
Yeah,
up.
the board certification isn't quintessential. It is a good indicator of what your specialties are. And one point that I do want to address, getting back to Justice Welch, your question related to the affidavit of merit, we didn't challenge the affidavit of merit in this case, because when you're filing an affidavit of merit, it's just what you reasonably believe the expert matches. And sure, you can go to Dr. Swofford's web bio, and it does mention that he got that certification. Yes, this is a neuroimage, so yes, they can reasonably believe it. What changes is when you get that affidavit of meritorious defense, and then you depose Dr. Swofford, and you find out what is your actual practice. How do you focus your practice? On what branch of medicine do you, it's only diagnostic radiology. At that point, then the plaintiff knows, I need to get someone to match him. There are no questions. If there are no questions, I'm going to keep talking, I guess. There is one point from the amicus brief that I did want to address, and it's the suggestion that the statute, if you don't change the interpretation, it'll bar defendants from being able to testify. First point on that, I'm aware of only one unpublished case that has said that. Not here to cure all the world's ills. I don't know the statute needs to be interpreted that way. But second, that's a poorly thought out point because of Reeves. Someone can still practice family medicine and take a shift once a week in the ER. That physician will not spend the majority of their time practicing in the ER. So you're not fixing that problem by doing what the negligence section has suggested. point that anyone followed that point or was worried about it. Hopefully they address it. I will reserve the remainder of my time unless you have questions.
I was distracted by that ding. So can you go back? You were just talking about Reeves. I've got a chart with all of these, so I'm trying to make sense of Jilic and Reeves. So the way that you see it, Reeves is the only one that doesn't fit.
So the only real problem with Reeves is that we don't know more. That physician could have had a family practice board certification, could have been practicing as a family practitioner and taking a shift in the ER once a week. That physician could have completely abandoned family practice, still been board certified in it, but hadn't practiced it for 5 years and had been an emergency medicine specialist for 5 years. That physician could have, not had a family practice and just happened to be walking through the ER. Like, we don't know. Well, all we know is the alleged malpractice happened in the ER, and that person was board certified in family practice. I don't have a problem with Reeves on the assumption that that physician was actually practicing emergency medicine. And I think it's probably a fair assumption that if that physician was in the emergency medicine or emergency room treating somebody, the hospital doesn't just let doctors come in and practice in that area, right? Emergency medicine is defined by being in the emergency room. So I think Reeves, is lacking detail, but it isn't necessarily wrong.
Does it conflict with Jilic?
No, and the important point there to understand between Jilic and Reeves is that in Jilic, the alleged malpractice took care at an urgent care. Urgent care is not an emergency room. It's a different level of practice and a different level of what the physicians have at their disposal. There is no board certification or specialty for urgent care practice. So in Jilic, that doctor was a family practice board certified. They're practicing in urgent care, and at least my experience is very similar to when I go to my kid's family practitioner. So I don't think there's anything wrong or inconsistent necessarily between Jilic and Reeves. It's just the facts. If that's what they're certified in, they're practicing urgent care. That's definitely not an emergency room.
So what if it had been an emergency room? Take COVID. A whole bunch of doctors got diverted to the ER. They were not ER physicians. They were all doing their best to help out in a crisis. I have lots of friends who did that. So what happens to them?
That's a really good question. So in that instance, I do think it's probably a determination for the trial court to make as a factual matter. Was this physician then focusing their practice on the practice and treatment in the emergency room? Or were they practicing as an emergency physician? Had they shifted sufficiently? If they're doing it one day on a lark to help out with the hospital, I don't think so. I think they're still going to be held to the standard of care of,
Or whatever their
surgeon
practice
or
area
whatever
is.
they happen to be, right? What would a general surgeon know if they're, in a pandemic showing up to help out at the emergency room, right? Is that doctor going to be held to the same standard of care as somebody who has been practicing in an emergency room for 2 years? I really hope not. But certainly if they've been taking shifts in the ER for 2 or 3 months, they've developed some specializations, and I could see a trial court having to ferret that out, figure out and that is the first step I'm asking you to say, is establish what are the defendant's specialties, and then move from there. One, that's it. If there's more, figure out what the malpractice relates to.
Howard, appearing on behalf of the plaintiff appellee. I'm going to start with what I thought the primary issue was that this court wanted us to address, is whether or not Woodard was wrongly decided. And not surprisingly to the panel, to the court, I believe it was wrongly decided. And I believe, as I set forth in my brief, that there are 2 primary areas that the court erred in interpreting this statute. The first is that Woodard, I think, improperly conflates the concept of specialties and subspecialties and required matching of either or both, whichever was the one most relevant. That's, as Brother Counsel said, it's inconsistent with the statutory language. We as lawyers and judges and presumptively legislatures appreciate the importance of using precise language. And here they used a precise term. They said specialty. You have to match the specialty. The statute never mentions the concept of subspecialty. And I think that's important in this case because there are other statutes that the legislature has enacted that clearly indicate that they understood that there was a difference between what a specialty is and a difference between a subspecialty. And when they meant both, they said both. So the fact that the legislature chose to use only specialty in this statute has to be given some effect. And the effect is that it requires the matching of only the specialty, not the subspecialties. Now, the defendant says, well, Woodard was a unanimous decision. And I agree it was a unanimous decision. But prior to Woodard, there were at least 2 published Court of Appeals decisions that looked at that same language and reached the same conclusion I did, or I proposed in my brief. And that was Watts and Hamilton prior to its reversal. Watts in particular said, but we presume that the legislature was familiar with the term subspecialty when it acted the provision and the legislature chose to use specialty, not subspecialty. We see no grounds for imposing a subspecialty requirement. So it's inconsistent, this conflation of these 2 concepts is inconsistent with the statutory language. It's also inconsistent with what a specialty and a subspecialty is. Woodard itself defined subspecialty based on Dorland's medical dictionary as an area of medicine in which one can become board certified. Now, the court went on to say that a certificate of added qualification for a subspecialty is a board certification. It, however, truly is not. Board certification is not available for subspecialties. All you can get is a certificate of added qualification. If it said certification, that may give more credence to the defendant's position, but it didn't. It said board certified. You must be board certified if the defendant is board certified. They required that level of certification. We know board certification is not the same as a certificate of added qualification outside of Woodard, based on several things. First of all, if you even look at Dr. Swofford's CV and his biography, he says, I was board certified in diagnostic radiology and I earned a certificate of added qualification in neuroradiology. The defense counsel, when he deposed Dr. Berger, who was our expert, made a very big point of cross-examining him regarding the accuracy of his affidavit, because in his affidavit, he said, I was board certified in neuroradiology, and that was used because that was what's required by Woodard, and he said, no, that's not actually true. It really is a certificate of added qualifications. And if we look to cases prior to Woodard, prior to the defense bar starting to make the argument that these CAQs and subspecialties were in fact subspecialties, we have cases like Halloran and Grossman where the defendants themselves conceded a certificate of added qualification is not board certification. And then I think if we look also to the idea of what a subspecialty truly means, if you look at Dorland's, which the Supreme Court in Woodard looked to in defining specialty, it says a subspecialty is a branch of medicine subordinate to a specialty. It's not the same. It is subordinate to a specialty. And look at the American Board of Medical Specialties or the AMA boards or the DO boards, and you look at those and they even draw the line. These are the certificates, these are the added qualifications, and they vigilantly guard what becomes a specialty and what remains a subspecialty. And we know that because if you look at vascular surgery in 2004 when the Grossman decision was decided was a subspecialty. It's now, since 2005 or I think 2006, it became a specialty. So they decide what elevates to a specialty and what remains the subordinate subspecialty.
What should we make of the fact that the American Board of Medical Specialties stated in its amicus brief in Woodard that a subspecialty constitutes a specialty, which of course the court recognized in a footnote.
Yes, it's a subspecialty. I mean, because it uses the word specialty within its definition, I mean, within its name, so it is essentially a specialty, an area of medicine. But is it what was meant by specialty in the statute that we're looking at? And if we look at, even if we look at McDougall, for example, I think it was Justice Taylor, when he was sitting at the Court of Appeal, cites the legislative history. Even the legislative history indicates that it was desirous of protecting or making sure that lawsuits brought against specialties that are high risk, neurosurgery, OBGYN, orthopedic surgery, they were all specialties. Never once did anybody say, oh yeah, and cardiology, or instead of orthopedic surgery, let's worry about sports medicine. They were focused on the idea that we don't want OBGYNs testifying against family practitioners who deliver babies.
But doesn't your argument open the door for a situation where the expert might have the same broader specialty, but what they are actually doing is focusing in a subspecialty, but they do, you know, they do both, and it doesn't have anything to do with what the defendant was practicing at the time.
Right, no, I understand what you're saying. We have to remember that there's 3 tiers to this statute. The first statute, subsection 1 and 2, requires the matching and spending the majority of your time in the same matched specialty. Subsection 3 gives the court the latitude to make that determination. And contrary to what the defendant is suggesting, I am not suggesting that this construct that I've suggested is not going to revert back to what we were before. We're not going to have a family practitioner testifying against an OBGYN just because they both delivered a baby. We're going to have, in that particular example, we might have an OBGYN testifying against another OBGYN who delivered a baby. And if the expert happens to be a maternal fetal medicine specialist who delivers babies, then he still should be equally qualified to testify. I think that requires a more focused look at what the claims in the case are and whether or not the sub-certification or the other practice areas would affect the expert's ability to give reasoned, valuable testimony. We can't have a case...
Aren't you just arguing that we go back to the earlier version of the statute?
No.
That said in the related specialty
No.
would be enough? Isn't that what you just said? You have to look at whether they're related?
No. What I said was, you look to see if the expert is boarded in the same specialty, spends time in the same specialty, and if they do, if the expert or the case involves a subspecialty, then you need to evaluate whether or not the subspecialty is something that needs to be considered. Let me give you an example. All right, I'm trying to think of a good one for you. If you have an internist and the defendant is let's say the defendant is a cardiologist, and the claim is that this expert, who's a board-certified cardiologist, no question, is treating a patient, and he fails to give him an appropriate antibiotic following a surgical procedure. He gave him something he was allergic to, or he failed to look to see what was the antibiotic could be effective against. So he just failed to give him the proper antibiotic. He's a board-certified internist. He's also a cardiologist, and it dealt with the issue of whether or not he gave an appropriate antibiotic. There's no reason why a general internist could not testify even though he's not matching cardiology. The statute, as it's written now, requires you have to match cardiology. So an internist, despite the fact that he's practicing the same overriding specialty, you don't turn off everything you learned as an internist once you start practicing as a cardiologist. he should still be able to testify. Now, if the case is something more specific to, more focused on the cardiac nature of the case, then there might be some additional requirement for the court to say, I think in this particular case, this expert needs to know more about these cardiac issues and have some training, education, or experience in cardiology, and then they can make that requirement. And that's quite frankly, I believe, why they put number 3, subsection 3 in. If we didn't have any ability to weigh or measure, then it's unnecessary. If we have to match everything down the road and there'd be nothing to weigh or measure. The weighing or measuring only comes in because they only required you to match specialties. Subspecialties were not required. The other problem, as I see it, is
Wouldn't the best matching be someone that has very similar, not just this higher, what you're calling specialty, but actually matches at the lower level? I mean, wouldn't that be ideal?
in some cases, it may be what the court will ultimately conclude would be the requirement.
But wouldn't we have maybe cases, courts right next to each other with very similar situations, and one judge saying, yep, that's good enough, the specialty matches, and, given the specific facts of this case, that's all that we need, and then in courtroom next door, then it's like, well, no, this fact is a little bit different. I mean, we could have cases all over the place that are coming down in different areas of what's required.
That's true. However, but what we would have is we would not have what we had before, these very divergent specialties testifying against one another. We would have the specialty, and then if there's subspecialties at issue, then we can match, the court can require that. There has to be some ability to weigh and measure, because there is no way to create a one-size-fits-all rule. Because even the defendant acknowledges that, because looking at Reeves, he says, well, the court's going to have to decide to see if they're really an emergency room doctor, if they're really a family practitioner. So
But don't you get closer if you treat the subspecialty like a specialty?
no, I think you get called closer the other way around, because at least you have people who are practicing under the same umbrella. Let me give you an example. If we treat specialties and subspecialties as totally divorced from one another, there are several areas of subspecialization that you can get from various boards. So, for example, critical care, you can get that through anesthesiology, you can get that through internal medicine, and you can get that through obstetrics and gynecology. If we completely wipe out the overriding specialty, then we're going to have a critical care person who's doing anesthesiology testifying against a critical care person who was boarded under obstetrics and gynecology. There's absolutely no reason that would not be allowed under under Woodard's constellation.
What if you flipped it and you didn't divorce them of each other, but you put them more on equal footing? So in your example, a certification in critical care in 2 different specialties, I'm just saying treating them as its own specialty.
Right.
So that's
separate
here, and then you're finding an expert that matches up.
But you're still having the same problem. You're going to have a person who was primarily trained as an obstetrician gynecologist testifying against a person who was primarily trained as an anesthesiologist, simply because they have 2 different subspecialties. And I don't think that's what the court would have allowed.
I'm saying that the subspecialty of critical care anesthesiology is its own specialty. Not that if you have a critical care subspecialty in one area that you can testify against someone in a different area. They move up to specialties.
Problem is that's not how they are structured in reality. In medicine, the way they train these people is you're trained as an internist. If you look at any one of these subspecialties and you look at their definitions under their boards, a critical care specialist under anesthesiology is an anesthesiologist who specializes in critical care medicine. Obstetrician, OBGYN's critical care medicine, an obstetrician gynecologist who specializes in critical care. They are first and foremost their overriding specialty. That is the problem that Woodard had. Woodard failed to divide them. They failed to recognize that they're not the same things, that a subspecialty is, by definition, part of its overriding specialty, and you can't separate them out from one another. So in my example, there would, critical care anesthesiologist should testify against an anesthesiologist with critical care, but that would require the matching of two specialties, which Woodard specifically said we don't have to do. We match the one most relevant specialty. Here, what we have is a circumstance where you say the one most relevant specialty is the overriding specialty, and then we weigh the facts of the individual case to determine if there's any greater need for consideration of education and training in the area of the subspecialty.
Doesn't it, I mean, just sort of getting back, I mean, I think, and I might agree that it sort of, in a perfect world, would make sense, the way that the chief sort of says, well, sure, if you have a subspecialty that crosses multiple specialties, you could still sort of keep apples to apples. That might make sense, but now aren't we saying that not only does the word specialty that the legislature chose mean specialty, it also means subspecialties, and it also means that if there are multiple, if it's a subspecialty that can be a part of multiple specialties, then those subspecialties have to match to this. I mean, we're putting a lot into the word specialty that the legislature chose.
Yeah, but I think that's if you apply Woodard. Woodard puts that in. I think this interpretation that I've indicated that I think is the correct interpretation is you match only the specialty. We're not worrying about subspecial for the purpose of matching and spending the majority of your time. We're not worrying about whether or not you're in the subspecialty. And part of the reason is because it's extraordinarily difficult for not only for the judges, but for the doctors to portion out what they're doing at any given time. Now, we always use internal medicine as the example. It seems to be the pull, because internal medicine is probably the one area of medicine where it might be the easiest to say, well, this is cardiology and this is internal medicine or nephrology or whatever. But what if the same rule has to apply to other areas? So what do we do with sports medicine and orthopedic surgery? It's virtually impossible to divide the two because they essentially do all the same thing, one in the context of sports and one in the context of every other injury known to man. OBGYNs and maternal fetal medicine. The only real difference there is that the patients that the OB is treating are a little bit more high risk, but the work is essentially the same. So we're asking, and if we look at what has happened in the lower court, when we make that request, divide out your time, doctors, we have circumstances where the doctors say, I just can't do it, because there is so much overlap between this specialty and this subspecialty that I can't tell you which one is which. Then you have in the case in Turkish where the doctor outright said, I spend most of my time in sports medicine and doing sports medicine procedure, and lo and behold, the person who couldn't divide out his time was disqualified as an expert. And in Turkish, the court said, you know what, that expert can testify because that expert said it was all under the rubric of orthopedic surgery. It's chaos to expect doctors or the judges in any case to try to ferret out what a person is practicing.
So to your example there, so that's an interesting one. Does it matter, and I don't know, is there a different standard of care between a sports medicine orthopedic doctor and a general orthopedic doctor? It seems like if the standard of care differs, then it seems like it's a different discussion. Because it seems like, obviously, if they're doing literally the same thing all day long, then probably the standard of care is the same.
I would agree with that, except for the fact that Woodard makes no distinction. They don't care.
Understood,
They
right.
don't care if the standard's the same.
Right.
They're saying you must divide your time, and it's just not feasible. And even in this particular case, if you look, you know, the defendant keeps saying, I'm really just a diagnostic radiologist, but he was trained, certified, worked 10 years as the head of neuroradiology, and just because I decided not to make that my primary focus, I'm no longer a neuroradiologist. It seems unreasonable to expect to say that he can just turn it all off. Plus, we have to look at the fact that, you know, the defendant suggests if he chooses to switch his focus to diagnostic, he's no longer neuroradiology. But I don't know anything anywhere that says what percentage of time a specialist must spend in a specialty to be a specialist. We have cases where people have said, I spend 30% in this, 30% in this, 20% in that, and 10 I do administrative. So it's a quagmire. And I think even if you left Woodard in place, what the defendant's asserting in this case is that he was not a neuroradiologist is inconsistent with the fact and inconsistent with his education, training, and experience. So unless the court, I believe I'm way out of
So
time.
I actually do have one more question. Let's assume he didn't have all that experience.
Right.
He was just a general diagnostic, you know, doing general diagnostic radiology, which meant occasionally he had to read a neuroimage. In that case, would you be saying he was doing, at that moment, the alleged malpractice was that scan, but he definitely did not have all that prior work experience?
I would agree with that. I agree with brother counsel on that regard. If you have a person who is trained solely as a general diagnostic radiologist, and he can read this film or study as part of his radiologic activities as a diagnostic radiologist, then he's practicing within his specialty, and that is his specialty. So I have no problem asserting that would be acceptable.
What if that same doctor, with everything that you just described, has, through the course of their work, had to look at a lot of neuro film? You know, do they have to say, well, I've looked at this many, I don't specialize in this, I don't have any specialized training, but yeah, you know, just the normal course of my work,
I do it all the time.
30% of what comes across my desk is that type of film.
Yeah, that's a harder question, but I think in that case, I think if you don't have the education and the training, I think simply spending, let me ask you how much of your time. I think let me give you an example. It's the best way I can do it. I had a case many years ago where the defendant doctor was a board-certified obstetrician gynecologist. He left that practice and became, I don't even know what the specialty would be, but he became an addiction medicine specialist, helping people detox from various drugs they might be on. What specialty is he? He's boarded, trained, and educated as an OBGYN, but he spends 100% of his time in a totally different specialty. Now, in that circumstance, I'd have to say he's something different. He is the addiction medicine specialist. But if you're a diagnostic, I think in the example of a diagnostic radiologist who sees anybody or read any film that comes in the door, and it just happens that for some weird reason you tend to have a lot of neuroimaging studies, I don't think in that particular example that would make you a neuroradiologist. I think you're still a diagnostic radiologist. I think if you abandon, especially if you don't hold out a shingle saying, yeah, oh, and by the way, I do neuroradiology. So
Yeah, but what
bring
if
them
you
all to me.
stop doing that? I mean, that's, you know, I mean, the example you just gave of
Right.
the OB,
Right.
you know, they stop doing that and they shift to something completely different, but, you know, somebody asks them to help out and they come deliver a baby, are they back under that specialty?
Theoretically, yes, because that was what he was trained, boarded, and educated in. I think once you have the training, that it should remain your training and your education. I mean, like, for example, if you stop being a lawyer and you do something else, and somebody asks you a legal question, you probably could still give them a legal opinion. You don't stop being a lawyer. You don't stop being a lawyer. You're not practicing any longer, but you're still what you were trained to be. And especially in Dr. Swofford's case, where it was just a couple months before that he discontinued, he gave up his certification.
So is it both then? It's both what you're certified in and then also what you're doing at the time, if it's a lot of the time?
Yes, because look at Woodard. Woodard talks about it's where you focus your practice, especially in an area where you've been trained and can be board certified. So if you've been trained in an area, you're a trained specialist. If you choose, based on your own interests, to focus your practice on one individual thing, let's say you're an internist and you just love the concept of infections, so you focus on treating infections only, and you become an infectious disease specialist because you can, because you don't necessarily need the training, you just need to focus your work in that particular area. So I think you have to look at multiple things, but that's why it's difficult to say when does somebody stop becoming a specialist in one and start becoming a specialist in the other. In my example with the OB and the pain management, he never did any specialty training in pain management. He just totally stopped and focused his practice all on the other thing. Thank you.
You have 2 minutes.
So what I heard at one point in the argument is that we agree that Higgins was wrongfully decided, which is endearing to me because I represented the defendant in that case. That was the case where the diagnostic radiologist read a neuroimage and he was told that he's going to be held to the standard of care. So we're making progress. The one point I really want to emphasize for you in relation to Woodard is I would hate to see this court overrule a unanimous decision of this court, of their predecessors, only to create more trouble. And that's what's going to happen. If you say specialty in this statute does not include subspecialties, you're going to create problems with MCL 62912A. That's the standard of care. And I really want to emphasize for you that this started with a motion to determine the relevant specialty. And to me, that speaks to what are we going to tell this jury the standard of care to hold this doctor to? If you don't clarify that you're not going to hold a doctor to the standard of care for a specialty he doesn't have, so that's the real inequity here. To have that physician who's a diagnostic radiologist sit there and be told to a jury he's held to the standard of a neuroradiologist. And I think it's just as wrong to have a cardiologist in a case and be told they're held to the standard of an internal medicine physician. Frankly, that just makes no sense whatsoever. That's what happens if you say specialty doesn't include subspecialties. There are two statutes in the same act, enacted at the same time, using the same term. That term has to mean the same thing. And you're going to have real problems, real social dislocations if you say specialty doesn't include these subspecialties. That I'll answer any questions you have.
Perfect timing.
Well done.
How do you do it?
Click your button.
You can hit the volume to go off. That was really
Justice ours did not work.
I'm tuned into
It worked well.
telecommunications. Yeah.
Any questions? No. Thank you both. The case will be submitted. Oh.